Okay, I think we are live now. I hope we are live now. So I'm going to kick off this event and welcome you all to the Planning Law Update, which is hosted by Francis Taylor Building. My name is Merrow Golden. I'm a junior barrister at FTB, and I am honoured to be chairing this event this morning. And it's an absolute pleasure to introduce to you both our two speakers, Michael and Jonathan. And they're going to essentially give you a whistle-stop tour of the key latest developments in the planning law world, both recent cases and also updates and changes to legislation. Because it may come as a surprise to some that notwithstanding this year of national lockdowns and global pandemics, it seems that the wheels of planning law have kept on turning, and there's actually been quite a bit that's been going on. So without further ado, let me introduce to you our two speakers this morning. They're two of our most recent recruits at Francis Taylor Building, and they're both rising stars at the planning bar, so definitely two to look out for. Firstly, we've got Michael Brett, who joined Chambers in April this year, and despite coronavirus has been hard at work and building a very busy practice. His practice and experience covers a wide range of planning and administrative law issues. And in addition to advising on planning law matters and appearing at public inquiries, Michael has recently appeared across the entire 3 weeks of the Brent local planning examination, and he's also currently acting as junior to Ned Westaway, another colleague of ours, in an ongoing challenge to a development consent for a wind farm development in Norfolk. He's also engaged in a number of town and village green matters as well. And on top of all of that, he's also found time to explore pastures new and is a founding member of Francis Taylor Building's Cannabis Law Practice Group. And then our second speaker is Jonathan Welch, who's our newest recruit to Chambers. He joined us in October this year, having during his pupillage gained a significant experience of across all Chambers areas, but in particular he's worked in planning and environmental and compulsory purchase law. He has already as well been developing a very busy practice, and he's recently appeared as sole counsel at a 2-week highways inquiry and at a local plan examination. And he's also been involved in a number of public order matters. And I'm also informed that he's due to appear as well, again as sole counsel, in an upcoming eight-day planning inquiry. So busy practices all round, and I think I'm going to leave it there and hand you over to Michael and Jonathan, who are going to essentially tell you all you need to know about the hot topics in planning law in the last year or so. Just to note, we are the event that's going to run over the 11 a.m. 2-minute silence. So I'm going to pop my camera off now, but around 11 a.m. I'm probably going to pop my camera back on and just pause our event for that 2-minute silence. Okay, great. I'm going to turn off my camera and hand over to Michael.
Good morning, everyone, and welcome to this legal update. It's great to be with you this morning. Just a flag that we're going to rattle through things fairly quickly because it's been a busy time. And I'm going to start off by talking about something I'm sure you've been bored to tears about already, but some key developments in statutory instruments to do with use classes and permitted development rights. So turning first to use classes, a very important piece of secondary legislation came into effect from the 1st of September 2020, and that's an amendment to the use classes order, and that creates makes a number of different changes to use classes, and in particular creates 3 new use classes, E, F1 and F2. And I'm sure you'll be aware of this, but perhaps the most important of these is the new class E, and that is an umbrella or portmanteau use class for sort of town centres uses. So it includes the old A1, A2 and A3 use classes, B1 and D1 and D2 uses. So there's a whole variety of different uses that are all going to be lumped together in class E. from cafes to professional services and normal shops. And we also have a reworking of the sui generis uses as well, meaning that pubs and drinking establishments are now in sui generis uses together with takeaways and cinema. So it's really worth familiarising yourself quickly with these new use classes, because they make quite a big difference. Next slide, please, Jonathan. And they have some key importance. The most important is that changes of use, as you will know, within a use class doesn't constitute development for the purposes of Section 55 of the Town and Country Planning Act. That means it doesn't require planning permission to make that change of use. And so all of a sudden, there's a great deal more flexibility with the sorts of uses that people who are now in Class E can change to. On the one hand, the idea, it seems to be behind those changes, is to allow high streets and town centres to be more flexible in the uses that they're put to, introducing greater variety of different uses other than what we have traditionally characterised as town centres, i.e. shops primarily. We've got gyms, we've got more professional services and health centres. They're all in there as well. But on the other hand, it significantly reduces the ability of local planning authorities to manage the uses within the town centre and to direct particular uses to particular places. So are we gonna, in our plan-led system, we might talk about this a little bit later as well, are we undermining that by this new use class? Are we creating new flexibility in the system? And finally, on use classes, one has to remember that lots of planning permissions are conditioned in such a way as to remove the ability to change use and restrict use to a particular use class. If that use class no longer exists, what's the impact on that planning permission? And I think we'll be advising a lot of clients in the future about conditions to planning permissions that make reference to old use classes and whether or not those conditions are still able to restrict the use in the way that they were intended to. So then, turning after our whistle-stop tour of Class E and use classes, let's turn to permitted development rights quickly. Two statutory instruments there at point 1 on the slide have come into effect, one at 9 AM and one at 10 AM on the 31st of August. Nice to see the draftsman come up with clever solutions. And I suppose two key headlines from this. One is about upwards extension of buildings. So firstly, the new permitted development rights allow firstly extension of existing dwellings up to provide more floor space for that dwelling, but also existing blocks and flats and terraces of 3 or more stories will be able to extend upwards in order to provide new self-contained dwellings. So that's the upwards extension permitted development rights. And then we also got a new permitted development right to demolish and rebuild vacant and redundant office and light industrial buildings. And that's another sort of headline change. There are other changes, so do look into those. But those are the two most striking ones. And again, why does this matter? Well, as I found out in doing the Brent local plan examination and working for residents generally, a lot of local people object to taller buildings in their area and are reluctant to support increased heights for a number of different reasons. But at the same time, especially in urban areas like London, there's a need to increase density of residential dwellings. And I think, one of the key things that's hoped this will happen is, one, just allow those increased densities to come into play, but also encourage local authorities to permit taller buildings, whether or not in their strategic policy making, because that needs to be made with the understanding that these permitted development rights to extend upwards exist anyway, but also on individual applications. If it's anticipated or it's reasonably likely that buildings will go upwards anyway, it's more likely perhaps that local authorities will permit taller developments in areas which may not yet be characterised by those taller buildings. And then finally, demolition rebuilding, there's a bit of a question mark there, isn't there, about whether or not that sort of development, which has the capability to provide a large volume of new residential units, should really be managed through permitted development rights, or whether it's better managed through the more formal planning permission development control structure. So that's a quick whistle-stop tour of those developments. Then now over to Jonathan, who's going to talk about the next topic.
Well, thank you very much, Michael, and good morning to everyone. I've grouped a few cases, you might say disparate cases, but I've grouped them under the heading of decision making. I think there are a number of cases from the last year which are of quite some interest on this. And the first category is what it means for a development to be in accordance with the development plan, and then I'm going to look at the tilted balance in the framework, and then some cases that look at how material considerations should be considered in decisions. So turning then first to the question in this case of whether a development was in accordance with the development plan as a whole. This is the Corbett and Cornwall case. And the court, well, the first question is, why is this important? Why is this an important question? Well, that's because particularly section 38(6) of the Planning and Compulsory Purchase Act has been referred to as the presumption in favour of the development plan. And indeed, if you are in accordance with the development plan, you have a reasonably good expectation that you might well get planning permission. So it's an important question whether you are in accordance. Nevertheless, as we'll see from this case, it's quite a broad judgment, the question of whether a development is in accordance. And so in this case, the facts of this case were that there was a proposal for new holiday lodges in an area noted in Cornwall to be of great landscape value. So it had two different policies that were really important for the development. One which pulled in favour, and that was the one that supported new tourism facilities, and one which pulled strongly against, which was that development won't be permitted where it would cause harm to features and characteristics of the area of great landscape value. So this is a perhaps not unfamiliar situation where you've got a development and two policies from the same plan which seem to pull in opposite directions. What is a decision maker supposed to do when there is no hierarchy of policies explicitly provided in the development plan? And so in this case, the council had found the proposal was going to cause harm, was contrary to the restrictive policy on harm to landscape value, but then nevertheless, taking into account particularly the tourism policies, the proposal was in accordance with the development plan when taken as a whole. So to the unfamiliar, it might raise eyebrows, but to those familiar, particularly with the Crane judgment, there's nothing particularly unusual about this. And it illustrates that even cases, even if there is a policy that's drafted in quite trenchant terms against development, a proposal might legitimately be found to be in accordance with the plan, and that will ultimately be a matter of planning judgment for the decision maker. But on the other hand, it might be the case that a single restrictive policy could mean there's a breach of the development plan as a whole, even though other policies support. So it will always be sensitive to the particular development. And I'm just, I think, going to pause in a moment for the 11 o'clock 2-minute silence.
That's good timing. So I think we're going to pause for 2 minutes now. Thank you, Jonathan. You're back on now. Just had a bell.
Thank you. So I was speaking before about the development plan and what it means to be in accordance with the development plan as a whole. And that Corbett and Cornwall Council is a good case for going to the authorities on the right approach to be taken to that planning judgment. And then I'm going to turn to a few cases that consider the tilted balance, the famous tilted balance. Well, what is it? It's a policy in the NPPF that affects the balancing exercise, ultimately, that a decision maker has to make. And where this tilted balance is in play, the development in question benefits from a presumption in favour. So it doesn't mean that all bets are off. It's not the Wild West. And there's a reminder, in fact, in this case, by the court, this Gladman case, that the tilted balance does not automatically lead to permission being granted where it's in play. And it still requires balancing of competing interests, but with a tilt towards permission being granted. So in this case, the court was concerned particularly with, when applying the tilted balance, what you do about development plan policies. And the court answered that question by saying that they're not to be disregarded, but they must still be taken into account and weighed, albeit in the light of this tilt to the planning balance. And the court gave, again, a helpful summary of the situations in which the tilted balance under paragraph 11 of the framework operates. The first situation is where there are no relevant development plan policies for that particular development. The second situation is where the most important policies for determining the application have been assessed by the decision maker as out of date. And the third, perhaps the most famous, is where there's a shortfall in the 5-year housing land supply, and that triggers the application of the tilted balance. And the policies important for the determination of the application are deemed out of date. Now, this case and the answer the court gave, I should caveat it by saying the appeal was heard in the Court of Appeal yesterday and Monday. So you can expect a judgment in the coming months. So do watch this space. The next case similarly was heard by the Court of Appeal, in fact, last month. And this was also concerned, the Paul Newman Holmes case is also concerned with the tilted balance. And the specific question here was whether the first part of paragraph 11D, if relied on, means that a single up-to-date policy in a time-expired plan prevents the application of the tilted balance. The answer given was yes. Even if you've only got one development plan policy that's relevant, which is not out of date, that can be sufficient to prevent the tilted balance. So it's not a question of simply whether the plan is is time expired, but whether the policies in particular are out of date. And so the next case considers this as well. And this is Peel Investments, which the Court of Appeal has already given its view on. Again, a case about the tilted balance, and the focus was specifically on what out of date means in the context of the framework. And here it said that there's nothing in the framework to suggest that the expiry of the plan period automatically means the policies in it are out of date. Policies will only be out of date for the purposes of the framework where they have either been overtaken by events on the ground or by national policy. So then moving quickly to my second chunk in this section of material considerations. And the Right and Resilient Energy Sevendale case provides a helpful exploration of what a material consideration is and what can lawfully be taken into account. Very briefly, the facts of this were a wind farm in the Forest of Dean, always a controversial type of development, and the promise that was made by the developer of an annual donation to a local community fund. And the court, very briefly, held that donation, financial donation to the local community fund, which had been taken into account by the decision maker, was not a material consideration because it was unconnected to the use of the land in question. And it was, the court said, in effect, an attempt to buy planning permission. And the court put things in quite strong terms and simply restated what are called the Newbury criteria for what constitutes a material consideration. So that's an important case for that issue. And then lastly in this section, the Sam Smith case from early this year So that right case considers, well, what is a material consideration? This case is about how you should approach material considerations in decision making. In other words, when is it an error of law to fail to have regard to a material consideration? And the summary, in short summary, a decision maker only fails in law if they fail to take into account a relevant consideration that they were under an obligation to take into account, whether it was so obviously material that it was irrational not to have taken it into account. So that the court put to one side some principles from a previous case called Bolton, which had said that you must take into account any matter which might cause the decision maker to reach a different conclusion than they otherwise would. So that's been put to one side. Instead, what has been restated is what's called the so obviously material approach to whether there's been an error of law in failing to take into account a material consideration. And with that, I will pass back to Mr. Brett.
Great, thanks, Jonathan. I'm going to tackle quickly a couple of cases about heritage that have come before over the last 11 months or so. And perhaps the most important of those is the decision of the Supreme Court in Dill. So if I can, next slide, please, Jonathan. And this is really an essential case for better understanding the statutory scheme for listed building control. And I recommend everyone who's able to read the case. It's pretty seminal, I think. And this focuses on the definition of a listed building in Section 1, Subsection 5 of the Listed Buildings Act. And that is set out there. But importantly, you will see from that definition that a building means a building which is included in the list, and also included in this definition is any object or structure fixed to the building, and also any object or structure within the curtilage of the building which forms part of the land and has done so before the 1st of July 1948. And that's the definition that this whole case revolves around. So turning to what they actually decided in that case, next slide please, Jonathan. This case was all about the removal and sale of 2 very large lead urns at a stately home in the countryside somewhere. And the Supreme Court essentially found 2 things. Firstly, it found that on an appeal against a listed building enforcement notice, it was open to the appellant to argue that in fact the listed building in question wasn't a building at all, and therefore there hadn't been a contravention of the listed building control. That's pretty important because previously it had been considered that you can go behind the statutory listing on such an appeal. You could argue that you hadn't undertaken the works, or the building wasn't of particular merit in some way, but you couldn't argue that it wasn't a building. So there's now the option to make that argument pretty much in any circumstance, it would seem, where a provision of law relies on this definition of listed building. So, for example, if the Section 66 duty in the Listed Buildings Act comes into play in a planning permission, and you're dealing with the need to the duty under that provision, and the local authority has to consider it, there is potential for an argument to be made that, oh no, we don't need to consider the impacts on this listed building because it's not a building. So that's the first point. The second point is, well, then if there's this discussion to be had about what is a building, what is a building? What terms do we use to assess that question? And there's 2 approaches you'll see in that definition in Section 1.5. Firstly, whether a thing is a building, and secondly, whether it's in that extended definition, whether it's fixed to on the curtilage of a building. So turning to the first limb, I think we can go back to that previous slide if you can, Jonathan. The same, we deal with the line of case law that we'll be familiar with from Skerritts and Barvis, which says that whether or not a erection or structure is a building for these purposes is a question of planning judgment involving a threefold test of size, permanence, and degree of physical attachment to the line. You remember the Skerritts case was about a marquee. And the Supreme Court in Dill clearly takes quite a restrictive view about how these criteria, this test, is to be applied. It's not enough simply looking at the sort of range of different things that are included in Historic England statutory list. It's not enough that they're simply things which are historically interesting or of particular artistic merit. The protection in the Act attaches to buildings and not other things, and it's relevant that the thing that is of interest must be either attached to a building, and its interest must reside in the fact that it is in fact attached to a building. So lots of the things on the list currently, such as road signs or commemorative plaques or tombstones, for instance, do these amount to buildings? Well, Lord Carnworth suggests not, essentially, and so that opens a whole range of arguments that might be made if you're dealing with a heritage asset which isn't a building, which is like a road sign or something. Even in a planning permission, you may be able to make a good argument that the impacts on it shouldn't be given the same level of protection that they have previously been given. Then turning then to the extended definition. This is really where we get back to some property law concepts, and really whether or not something is fixed. That notion of a fixture is one that should be familiar from real property, and essentially whether or not something is so permanently attached to the land that it's become part of the freehold estate and land. And there's a line of cases there. That's what we have to refer to when we deal with the fixture point. And we'll come on to the point about curtilage in a second, but it's worth noting that the Supreme Court gives a fairly clear direction, and Lord Carnworth does, about the sorts of things that won't be considered to fall within the extended definition in Section 1, subsection 5. And Lord Carnworth says a statue or other ornamental object which is neither physically attached to land or directly related to the design of the listed building cannot be treated as a curtilage structure, and so part of the building within the extended definition. So the Supreme Court is definitely circumscribing the definition Section 1.5 a lot more tightly than perhaps had previously been the case. So then turning to the next case I'm going to talk about on this topic. This is useful in the listed building and heritage sense because of its consideration of that word curtilage that we've met in Section 1.5. This case actually related to a application to deregister an area of common land at Blackbush Airport. And it's a very useful case because it considers in quite a lot of detail the state of the authorities about the meaning of this word curtilage. And what emerges, and I won't labour the point, but what emerges from this authority, I think, are two distinct legal meanings of curtilage. Firstly, there's a narrower meaning of curtilage, which is to be used in planning, used for planning purposes, and that is the test in the Methuen-Campbell case, whether the land in question, which is claimed to be curtilage, is so intimately associated with a building that it forms part and parcel of the building. And so this is the definition we should be looking at when we deal with permitted development rights, which include which cover development within the curtilage of a building. We're talking about a narrow definition of land that is intimately connected with that particular building. But this is not the concept that applies in the listed building arena, which is a much broader concept, and that's the Calderdale concept of curtilage. And in that case, the key question is whether or not land is associated with the building in such a way that the land and building comprise part and parcel of the same entity. And so this is a question which looks at the physical layout and the ownership and the use of function of the land and the building together, and come to a conclusion about whether or not they form a cohesive unit in some way. So there's this additional focus on the land itself rather than just the use and function of the building. So that's the takeaway really from the Hampshire case. And finally, looking at my final case here, this is a slightly simpler case really. This is where this is an example of where councils fall down on their Section 66 duty. Really, and it's quite a simple one in many ways. The council simply failed to refer in the officer's report to a formal consultation response from their internal heritage officer about the desirability of planning permission being granted here, which included the conversion of two grade 2 listed buildings into apartments. And this is, although the Section 66 duty was referenced perfectly properly in its statutory terms in the officer's report, the fact that such an important material consideration had been left out, and it was one of those material considerations that was obviously material, it really ought to have been considered, without which the decision would have been unlawful. But putting that to one side, such was the importance of this heritage response in the context of the Section 66 duty, that even though the council had made reference to it, this omission was enough to displace the presumption that that duty had been discharged. So this is a really good example of how local authorities should flag all relevant consultation responses at the beginning of their officer's report and make sure to deal with the Section 66 duty in a robust way. And that's our quick gander through the heritage cases.
Thanks, Michael. I'm going to whistle through some cases on environmental issues, particularly whistling through some EIA cases, over which there is continued, as ever, litigation with potential changes upcoming. There's a consultation this autumn on the EIA, and the planning white paper, it won't have escaped people's notice that has said it would sweep away EIA and SEA into one single process. So watch this space. It remains to be seen what happens. In the meantime, litigation continues. And so the first case I wanted to highlight is an unsuccessful challenge based on the EIA regime. And this was a challenge to the screening opinion. The screening opinion is an advice produced by the the local planning authority, advising whether EIA is required to be submitted for an application or not. So whether it gets over that threshold. And the crucial question for the decision maker there is whether the proposed development is likely to cause significant effects on the environment. And the simple take-home point from this is the Court of Appeal affirmed that the usual established position that the likelihood of significant effects is a matter for the decision maker. And the court emphasised the breadth of that judgment. And the mere possibility of an effect is not the same as meaning they must find there are likely to be significant effects. And the detail of reasoning required in such a screening opinion was noted by the court not to be particularly high. There's no need to set out all the information, and the courts were advised not to take too burdensome an approach to oversight of that function. And then to another case, which is another unsuccessful challenge along somewhat similar lines. This concerned the Sizewell, some enabling works for the Sizewell C nuclear power station, and the environmental issue in question was breeding birds. But important for our consideration is EIA Regulation 26, which requires information to be up to date if it's going to be relied on for a decision. And again, really, the court has emphasised that the meaning of whether information is up to date depends on the quality of that information, which is ultimately a matter of judgment for the decision maker, whose judgment can only be impugned on a legal ground if it's shown to be irrational. So another case showing how difficult it is to challenge on this sort of basis. Another case along similar lines concerns, amongst other things, the duty to consider alternatives. And the second ground of challenge in this case was about the sufficiency of information contained in an environmental statement. And the Court of Appeal held that the information there was sufficient, even though it was pretty slim. It simply said, in terms of alternatives, that the site was to some degree isolated. And it took its assessment of alternatives no further than this. So I think that really shows the high point almost of the court's unwillingness to interfere on this point. However, the next case is a cautionary tale, because on this case, the challenge to the screening direction by the Secretary of State was successful. The facts of the case raised eyebrows, perhaps. It's a former BSE carcass rendering site, and the issue was about contamination, possibility of contamination. And the issue here really was about whether the Secretary of State issuing the screening direction was entitled to rely on conditions which required investigation and assessment of contamination and amelioration schemes, whether the Secretary of State was entitled to rely on those conditions as being sufficient to preclude a finding that there were likely significant effects. And the court held in that case that there was not sufficient evidence before the decision maker of the extent of contamination, or how, or even whether this contamination could be resolved in order to make an informed decision. So this is a salutary tale, perhaps, that whilst these sorts of challenges are not often successful, one does have to be very careful as a local planning authority, or indeed as a Secretary of State on screening direction, not to rely without thinking on mitigation conditions, but to assess, to investigate and think about and form a judgment on how effective they will be. So then I turn to a couple of cases. I'm going to cover these very briefly on climate change. The highest profile, which won't have escaped people's imagination, is the Heathrow third runway so-called case, although in fact it was a challenge to a policy statement, the airport's national policy statement. And in this case, the Planning Act 2008, which provides an alternative regime to the Town and Country Planning Act. The Planning Act provides a regime for nationally significant infrastructure projects. This was a challenge to the designation of a policy statement, which the legislation requires that in designating the policy statements, the government has to, well, the Secretary of State has to take into account government policy relating to climate change. And in this case, the question was, because the UK had ratified the Paris Agreement, was that government policy at the time they designated the national policy statement for airports? And the answer the Court of Appeal gave was yes, it was. Now, this has just been argued in the Supreme Court, so we can expect judgment on that soon. But that, I think, is just an interesting example of the court taking very seriously the issue of climate change, very seriously indeed. And the final case, the Drax case, which is about gas-fired units in North Yorkshire. And there are a lot of grounds in this case, quite a complex case, but just really two areas that I wanted to quickly focus on. This, again, is a nationally significant infrastructure project. So we don't look to the NPPF, we look instead to the specific policy statements that are designated for the purpose of that type of infrastructure. In this case, policy statement EN1, which is the overarching policy statement for energy. And the purpose of this new regime for infrastructure planning really is to establish at the policy stage the need for that type of development. So you don't have to, at the examination, go into the question of whether that type of development is needed every time. And these infrastructure inquiries used to take a very long time indeed, because those questions had to be resolved on each case. Now here, I think the court has emphasised, amongst other things, the focus is on the policy stage being when you decide about the need for that kind of infrastructure. Also of note in this case was the reliance on other regimes and mechanisms. So here, whether the Secretary of State ought to have gone further to consider greenhouse gas emissions, or whether the Secretary of State could lawfully have relied on other emissions regimes. And the answer the court gave was the Secretary of State was entitled to rely on those other regimes and mechanisms. And that's in accordance with, well, that lines up with principles in the NPPF at para 183 and what are called the Gateshead principles. And so I think that's the second interesting topic, very briefly, considered net zero target for greenhouse gas emissions and whether that made a difference and should have been taken into account. And it was held that the judgment of the Secretary of State was okay on that. So I think this shows the uphill challenge that claimants face in challenging national policy statements, although the Heathrow case was successful, and also particularly the uphill struggle in challenging development consent orders under the 2008 Planning Act. And with that, I will pass back to Michael.
Thanks, Jonathan. We're running up against time. There's so much to talk about. So I'm going to quickly gander through 2 or 3 cases on the Green Belt. And the first is another very important Supreme Court case, and Jonathan's already referred to it in the context of material considerations. But essentially, this is a key case for considering the concept of openness of the Green Belt that you will all be familiar with as one of the essential characteristics of the Green Belt in paragraph 133 of the NPPF. You'll also remember from paragraph 146 that some forms of development are not inappropriate development in the Green Belt, provided they preserve its openness. And one of those types of development is mineral extraction. And in this case, the Supreme Court was considering whether or not Yorkshire County Council had to consider the visual impact of a quarry when considering whether or not that quarry preserved the openness of the Green Belt or not. And so, turning to the next slide, the Supreme Court had a number of interesting things, some of them very gnomic, to say about the concept of openness. It's a quintessential type of broad policy concept, and really whether or not something preserves or openness or doesn't is a matter of planning judgment at the end of the day, and the court's going to be reluctant to interfere with that. But clearly, openness isn't the absence of development, and there's some dicta in previous cases about that. Some forms of development are definitionally appropriate in the Green Belt and therefore preserve its openness, and also some may be appropriate, and such as those in paragraph 146. So what that means is that openness isn't a spatial or volumetric concept, but really it's like they said, it's a broad policy concept. There's lots of different factors that might be relevant, and one of them might be the visual impact of a development, but the visual impact is not necessarily necessary to an assessment of openness. It's not a concept about landscape. It's a concept about preventing urban sprawl. It's the other side of the coin from urban sprawl, and the Supreme Court comments that actually perhaps a quarry is just as good at preventing urban sprawl as some agricultural fields, perhaps even more so in some ways. So turning to the next slide, those are the sort of commentary on openness. It turns out that Yorkshire's approach to openness was perfectly fine. They didn't need to go into a detailed assessment in openness terms of visual impact, but there may be other circumstances and cases where they do need to do that. And in 2 subsequent cases also this year, Hook against Secretary of State, also in the Court of Appeal, and also the case I pointed you towards before, the Liverpool Open and Green Spaces Community Interest Company case. They both contain further digests of various principles to do with openness, some with somewhat different emphases from Sam Smith. So it's worth bearing in mind that I think there's going to still be some judicial jostling about exactly how openness is properly to be considered. Turning to the next slide then, a quick point towards the Compton Parish Council case, and this provides some really useful analysis. It's part of the scholastic interpretation of the NPPF, very granular about what exceptional circumstances mean in paragraph 135 when considering whether or not to remove land from the Green Belt as part of the local plan process. And essentially, the line again is planning judgment is king. Exceptional circumstances don't have to be they don't have to be more than one circumstance. but at the same time, exceptional circumstances could be the accumulation or combination of different circumstances. What matters is whether or not the circumstances in question are sufficient to warrant altering the greenbelt boundary, and that's a matter of planning judgment again. And also, exceptional doesn't mean the circumstance is unlikely to occur again. It simply means that whether or not it's such as to justify removal of land from the greenbelt. So that's a key point there. And then I'll skip over the next slide and just point you towards local auto investments, which is a case about one of those policy areas where greenbelt policy is applied by analogy. Local green spaces, they're green areas where development management is managed sort of in line with development in the green belt, so the very special circumstances test applies. And essentially, this case considered where a neighbourhood plan policy was more restrictive than the MPPF. That wasn't necessarily fatal to its legality, but what had to be done is proper justification provided for why that policy was more restrictive, and in the absence of that justification, the policy will be quashed. And so it shows also perhaps the limit of neighbourhood planning, well, perhaps the opportunities and also limits of neighbourhood planning to help local people get around greenbelt reviews and greenbelt restrictions in their statutory development plan or national policy. So watch that space. There's some other cases there as well, but my time is up on that. Over finally to Jonathan to cover the final topic.
I think, given the time, I'm just going to give these two cases to you all for your note, really. The first is DB symmetry, the second is fini. And the DB symmetry case, it can be summarised. It's basically about, should the court go out of its way to save a condition which seems to have been unlawfully worded? Should it save the planning permission? And in this case, the court did. It applied what's called the validation principle, and construed the condition with reference to the reasonable reader. So that's an important case for your note for that topic. And then the second case is called fini, which is another important case, the Court of Appeal, and that concerns a Section 73 application, which is an application to amend. And the crucial point from that case was that Section 73 applications cannot be used to alter the description of development, but only the conditions. So that may lead in the future to ever more bland descriptions, but that's worth bearing in mind. Another important case for your reference. And I think there I shall finish.
Bang on time, bang on time. That was a very impressive speedy run through of many areas. I think Michael has been responding to questions. Thank you for your questions in the chat. And I think I'll just add to what Michael said about the in relation to Dan's question about whether the use classes order is currently standing or whether it's being sort of on hold during awaiting the challenge. To my knowledge, there was initially an application to have the legislation on hold, but as I understand it, that application was withdrawn. So Michael's quite right that currently, to my knowledge at least, the used classes order does stand pending that case. So thank you very much for the question, and I think it's now just left to me to thank you for attending and watching, and thank you to Michael and Jonathan for those talks.
And it's worth, isn't it, Merrow, pointing out that our slides hopefully will be made available on the FTB Chamber's website, hopefully over the course of today. So if we've gone too quickly and you'd like to go back over anything we've said, check later on after lunch maybe, and hopefully they'll be up.
Quite right. Thank you, Michael. Yes, we're going to try and make those available to you as well. Great. Thank you very much.
Thank you all.
Thanks all.